Advertising Lawyers Alliance. It's an organization collecting advertising and marketing lawyers from all over the world. More details about us, about GALA, you can find on the webpage galalaw.com. It is my pleasure to introduce you today's speakers, which are in the order as they will speak. José Maria Alves Pereira from Abreu Abogados from Portugal. Hello, José. Then Carolina Montero from Abril Abogados from Spain. Then Daniel Mwathe and David Opijah, both from Bowmans, Kenya. Then we have Dozie Ezeh from Kayode & Co. from Nigeria. And last but not least, from Israel, David Wolberg, representing Kuperschmit, Goldstein & Co. Hello, everyone. Before we start, let me give you some technical info. This webinar is planned to be approximately 1 hour. If you have any questions, comments, or observations to share, you can share them through Q&A option. Q&A option you can find on the very bottom, very right part of your screen under the 3 dots. When you click on them, you can see Q&A part and you can pose the questions. I will be watching it as the speakers will speak and will interrupt them or will pose them at the end. Of course, there will be time for raising the questions at the end. Another technical information, this webinar is being recorded and every one of you who registered for this webinar will receive the link with the recording. For some reason, if you have a reason to leave the webinar, you can, let's say, listen to it in the future. We have structured this webinar to give you the most recent and the most important information about food and beverage advertising into certain subsections. The first subsection is, or will give you the brief overview of the regulatory background. The second one will be basically the core of this webinar, which will give you the hot topics and the most important things that are happening now in all of the jurisdictions. The third one will give you some overview of the sanctions, and we will end up this webinar with short summary and key takeaways that you will have from each jurisdiction. So going to the first part of our webinar, we will discuss in the order of the countries as I introduce them about the regulatory landscape. We will show you which of the jurisdiction is the self-regulatory system or which jurisdiction is a statutory system. We will introduce you or give you the brief overview of the bodies and entities that are part of this system. So without taking this introductory part too long, let's jump into it. And I'm giving now the floor and the microphone to José to let him speak about Portugal. José.
Thank you, Dusan. Good afternoon to all. I would like to start to the definition what is considered to be advertising law. So in Portugal, when we talk about advertising law, we are basically describing the set of rules, legal rules that apply to the activity of advertising. And as a basis, we need to consider either the Portuguese constitution, which recognizes advertising as economic activity, and the Portuguese advertising code that sets the basic rules to be followed by advertisers. We also need to consider lex specialis that we'll see after, but let's now focus only on the Portuguese advertising code. So this decree law basically is a dual scope law. It either protects the freedoms and interests of consumers and also intends to promote and protect a healthy competition between entities. It is a principle-based law, so it sets the 4 main principles to be followed by advertisers, which are, first of all, lawfulness. So basically, any advertisement must comply with the applicable law, any law. For instance, an advertisement that uses a third-party trademark on an unlawful way, which will not be complying with the lawfulness principle. It also prohibits advertising to encourage violence or criminal activity and discriminatory practices. The principle identification, which simply requires any advertisement to be clearly identified as such, thus prohibiting hidden or subliminal advertisements. The principle of respect for consumer rights, basically it requires the advertisers to comply with consumer law. So now we are in lex specialis field. And there is a general rule of the need to use Portuguese language in all advertisements. Of course, there are exceptions, but this is the general rule. And last but not least, the truthfulness principle. It is a very important principle for the hot topics that we will discuss lately. And it simply requires all advertisers to use truthful information in their claims and be able to evidence such claims. Giving an example, if an advertisement of juice says 100% fruit, the advertiser must be able to evidence that indeed the juice is composed by 100% of fruit. If we can go to the next slide, please. So as I was saying, there is also lex specialis to be considered, not only directed to advertising per se. And I have to say that advertising is defined by the Portuguese advertising law on a very broad way. So it's basically any communication that promotes directly or indirectly a product or service, an idea or initiative. But we also have to consider special rules with regards to competition, unfair commercial practices, and also labeling that simply governs the information that must be mandatorily included in all labels of products. And this is especially relevant for food and beverages, as there are specific rules on a EU and national level that set the information that must be included in the labels. With regard to the regulation that is included in this slide, I want to also note that it also provides specific rules for the use of certain nutritional claims. Apart from law, in Portugal, we also need to consider the self-regulatory rules. There is a self-regulatory entity in Portugal. It is called Autorregulação Publicitária, and it has issues certain codes of conduct, as the code of conduct for advertising and other forms of commercial communication, and applicable to children also. And it is applied to only to the entities that are part or that adhere to this self-regulatory entity. Notwithstanding, it is important to say that even the entities that did not adhere to this entity tend to follow these codes, as they are considered to be as guidelines or best practices to be followed within the advertisement business. So I will now give the word to my colleague, Carolina.
Thank you. Good afternoon, everybody. Well, coming from Portugal to Spain, I think that the regulatory landscape is quite similar in both countries, especially being EU countries. And as you can see, we have 3 different levels of regulation in Spain. The first level is the Spanish law on food safety and nutrition that sets the legal framework for the adoption of public policies that encourage healthy eating and promote the practice of physical activity. Very linked with this law is the law that created in 2001 the Spanish Agency of the Food Safety and Nutrition, which is called AESAN, and is the equivalent of the European Food and Safety Authority, EFSA. And in the second level, we have the self-regulatory codes, especially the PAUS code, which is the code of advertising of food and beverages to minors, being a very special target that has a special regulation in the Spanish law with the prevention of obesity and protection of the health. And the strategy which is linked to that, which is the NOW strategy, meaning nutrition, physical activity, and obesity prevention. But not least, actually, as an umbrella of all these regulations, there are the European regulations, especially the Regulation 1169 of the year 2011 on the provision of food information to consumers that basically is an umbrella for every regulation that needs to be adopted afterwards, and the nutrition and health claims made on foods as well. In the next slide, we can see that specifically the Spanish law on food safety and nutrition provides a variety of laws that are also applicable when we are talking about the advertising of the food and other nutrients. And it's referred to the Unfair Competition Law, General Law on Advertising, Defense Consumers and Users Law, and all the complementary laws, and the General Law on Audiovisual Communication that are also directly applicable when we are talking on advertising of any food and nutrients. Also, there is a special protection of children under 15 years of age, which is based on two principles. The first, the code of self-regulatory, and the power of the government in the absence of such codes. In this regard, as mentioned before, we have the regulatory code of advertising of food and beverage of minors that was firstly adopted and subsequently revised from 2005 until 2012, and it was made possible for an agreement between the Ministry of Health, the Spanish Federation of Food and Drink Industry, the Association of all Self-Regulatory of Commercial Communication Auto Control, which was the initial instrument against any inappropriate advertising in this field. And now I leave the word to David.
Thank you very much, Carolina. With respect to Kenya, there is no specific legislation on advertising. Inference is, however, made from the Competition Act of 2010 and the Consumer Protection Act of 2012. In terms of self-regulation of advertising in Kenya, the two professional bodies involved are the Marketing Society of Kenya and the Association of Practitioners in Advertising. In Kenya, we have the Advertising Code of Practice and Guiding Principles that are developed by the MSK and the APA. Next slide, please. In terms of general law, first, we have the Constitution of Kenya. In our Constitution, consumer rights are protected under Article 46. A consumer is entitled to fair, honest, and decent advertising. The Consumer Protection Act of 2012 and the Competition Act of 2012 are the statutes that protect the consumer and also ensure that there is healthy competition in the market. We also have the Standards Act, Chapter 496. In terms of the sector-specific laws, we have the Food, Drugs, and Chemical Substances Act, Chapter 254, under which we have the food labeling regulations. And just as my colleague Carolina and José mentioned in their jurisdictions, in Kenya we also have self-regulation in terms of the Advertising Code of Practice and Guiding Principles. So the main principles of advertising set out in the code in relation to food advertising be legality, the principle of decency, honesty, and truthfulness. Next slide, please. Now, in this slide, we have the main bodies involved in the advertising sector, the Marketing Society of Kenya. We have the Association of Practitioners in Advertising. There is also the Advertising Standards Board. And we also have the Kenya Bureau of Standards. And again, we have the Competition Authority that is established under the Competition Act. I'll now hand over to David to continue. Nigeria, my colleague Dozie, if he's on, please.
Yes.
Thank
you
you.
very much, David. Okay, so I'll jump right in. In Nigeria, we have the Advertising Regulatory Council of Nigeria, which is the federal government body primarily responsible for the regulation of advertising in Nigeria. The ARCON used to be known as APCON, that is Advertising Practitioners Council of Nigeria. But towards the end of year 2020, this body was, changed to become ARCON because APCON was viewed as being a little more restrictive in the sense that its provisions, or APCON as a body, regulated advertising as regards advertising practitioners in particular, and not everybody else. And so ARCON is the body in Nigeria that is responsible for regulation of advertising generally. However, we also have sector-specific laws that regulate advertising. And for example, in the telecommunications industry, you have the Nigerian Communications Commission, the NCC, that is, in charge of regulating advertising and, sales promotions as concerning license holders. Now, the NCC is empowered, under the Nigerian Communications Act of 2003 and the Nigerian Communications Enforcement Act of Enforcement Regulations, of 2005, to make, publish, minimum standards regarding telecommunications advertising. Now, also we have in the financial industry, the Central Bank of Nigeria is, empowered to regulate advertising as regards, banking activities and advertisements that, involve depositing money in a particular institution. They do this, the central bank does this under the, Central Bank of Nigeria Act, as well as the Banks and Other Financial Institutions Act. That's section 40 to be specific. In the insurance sector, we have the National Insurance Commission, NICOM, which is the body responsible for regulating advertisements as regards the insurance sector. However, to come down to the topic of this particular webinar, which is food, and NAFDAC, which is the body in Nigeria responsible for regulating the registration of food-related products, is also the body that is responsible for regulating advertising as regards food. And NAFDAC is the full meaning of NAFDAC is the National Agency for Food and Drug Administration and Control. That's the meaning of NAFDAC. And they do this under the provisions of their Food Products Advertisement Regulations of 2019. Now, these regulations prohibits the advertisement of any food product unless it has been registered and approved by the agency. So it is not just the registration that is required. The advertisement also has to be screened and approved, pre-approved by NAFTA before you can, display such adverts in public. And then this Food Products Advertisement Regulations specifically prohibits the advertisement of breast milk substitutes, and that's for infants, and any food for young children and infants. And To mention, I think it's also important to mention that the approvals that can be obtained from NAFDAC as a body to advertise food products is valid only for a period of 1 year. So after the 1 year period expires, you will be required to reapply for another approval to advertise your food products. And in the case of default, where someone puts out an advertisement for a food product without obtaining prior approval from NAFDAC, the penalties can be usually quite heavy, and they come in the form of fines and a forfeiture of the whatever item it is you used to put out that advert. So I believe that is it for Nigeria for now.
I think it's my turn now. Thank you, Dozie. Hello, everyone. I'd like to mention first that in Israel, there is no self-regulatory body, not in the area of food and beverage anyway. There are primary laws, which are enacted in the parliament. And these primary laws will usually give a minister, a governmental minister, the power to set regulations. The ministers in this area, food and beverage, are usually the Minister of Health and the Minister of Commerce. They will usually consult with the Ministry of Health before enacting these regulations. If we're talking about primary law, I would like to mention the Consumer Protection Law, which is the mother of all laws in the marketing and advertising area. The Consumer Protection Law basically prohibits misleading consumers, which is very relevant to food and beverage, and it's relevant to all advertising and marketing. The Consumer Protection Law gave the Minister of Commerce the powers to regulate regulations, and he regulated the consumer protection regulations, advertising and marketing methods targeted at minors. Now, minors are a very important segment in this field of food and beverage, because often advertisers will give foods attributes that they don't really have. And minors, by the way, a minor in Israel is someone who has not reached the age of 18. So 1 to 17 is a minor. And minors are very easily misled and easily influenced. So you have to be very careful when you're advertising towards them, especially food and beverage. I'll read out the main gist. Advertising and marketing methods must be adapted to the knowledge, understanding, and maturity of the targeted audience. It prohibits encouraging minors to consume food that alters their body weight, which is very relevant in this field. Next slide, please. I would like to mention the protection of public health regulations, nutritional labeling 2017, because I believe it's very unique to Israel. It basically sets rules and regulations of how you warn the public that your foods that the food that you're advertising is has a high degree of salt, fat, and sugar. But I will mention that in the next round of questions that we have. Dusan, back to you.
Okay, so that was the regulatory background. Let's now skip without any obstacles to what are the hot topics, and let's say hot topics in food and beverage. Or are there disclosures, or are there any special things about meat replacing products, or what it is? So without any stops, let's jump to Portugal. José, the floor is yours. Before I say it, or before I give you the mic, I will have to mention that we are quite slow, or we are quite behind the time. So please choose the most important ones before entering, or choose the most important ones to describe. Thank you.
Thank you, Dusan. So in Portugal, we have two main hot topics: fat foods, which are foods with high content value of salt, sugar, and/or other saturated fats, and food analogs. And these are hot topics for different issues. For fat foods, it has been in Portugal a challenge for advertisers to comply with the restrictions that are posed to these so-called fat foods. And there is no definition of what is a fat food. Instead, we have a government order that sets the limits of these values of salt, sugar, etc. And if a certain food goes beyond that value, it is subject to these restrictions. And there are several restrictions that mainly intend to protect minors. In Portugal, minors are also persons under 18 years old. And these restrictions are with regard to the places where one can advertise these products, the content of the advertisement itself, and the medium used. I will not go through all the restrictions because of the time, but these are the main topics. With regard to food analogs, the law does also not provide for a clear definition of what is considered a food analog, but one should consider that it is any food product that is designed and manufactured to resemble another fruit product. And here we have three main risks for advertisers. First of all, denominations and labeling. Second, false and deceptive advertisement. And third, comparative advertising. The first two are mainly issues around the needs to identify the applicable law, because we are not dealing, for example, with a meat hamburger. If you have a plant-based hamburger, which law should I comply with regards to labeling? The one that sets the labeling requirements to meat or the general rules? With regard to false and deceptive advertisement, as I said, this is a very important topic, the truthful principle, because the claim used by the advertiser, must be chosen with careful. For example, if I have a product, a soy milk product, could I use the claim soy milk product, or as an advertisement, should I use a claim like plant-based milk analog drink? So the consumer knows that it is not really a drink, a milk, because it does not come from a mammal, but it is indeed a product that intends to substitute the regular milk. The same happens with meat. For example, use a plant-based hamburger and use the claim cruelty-free instead of lab-made. Of course, cruelty-free is an expression that is much more popular within consumers, because usually no one wants to buy a product that is lab-made. It does not sound as cruelty-free. And lastly, with regard to comparative advertisement, the main risk here is when comparing products, be sure that the same type of products are being compared. It is not possible to compare a regular fruit product with an analog product, because they are not indeed the same type, even though they tend to substitute one or another. So that's it. Thank you.
Okay. Thank you, José. I prepared three different set of hot topics. The first of which is I'll try to do it very quickly, and I'll answer any questions that you may have afterwards. The first one is the health and nutrition claims, covering labeling and the limit to advertising under the umbrella of the European regulation on the provision of food information to the consumers. As you all know, there is a mandatory nutrition labeling introduced for most processed food. The compulsory elements were energy values, fats and saturated fats, carbohydrates, sugars, and protein and salt. And Spain, together with some other European countries, established a transnational coordination mechanism to facilitate this labeling, adopting the Nutri-Score, which is basically the logo that you have on the screen in the slide. The Nutri-Score is one of the front of pack labeling models that is currently in the market, and reflects gradually from higher to lower the overall nutrition quality of the food, which is in line with the European regulation, and takes into account all of the mandatory declarations of this regulation. I have to say that first of all, it's voluntary. It's not compulsory to adopt this Nutri-Score labeling, and it has had lights and shadows because it has sometimes been accused of not being very clear. But to be honest, it's a very visual way to determine whether you should buy or not the product that is labeled with this Nutri-Score. And on the limits of the advertising, mainly the PAOS code, which is, as I mentioned earlier, self-regulatory code, divides and regulates the food advertising to children under 12-year-olds in the traditional advertising formats such as television, radio, press, and outdoor advertising. And there is a second layer of limits to children under 15 years of age when the advertising is broadcast via the internet. In the next slide, I have for you this, well, it's a new draft regulation that it's being redacted under the new directives and Parliament suggestions supporting the member states to review the relevant provisions to restrict the advertising of sweetened beverages, processed food, products high in fat, salt, sugar, including the advertising social media that has been pushed through Europe, not only by the Parliament, but also by the Commission and by many lobbies, and has been translated in Spain into a new draft regulation, a royal decree that establishes minimum criteria for the prohibition of advertising to children of food and beverages high in these certain nutrients, but nowadays has been stopped because probably you all know that we are trying to form a government. Is not being easy, and this is one of the new regulations that is being affected by the political situation. And last but not least, in the next slide, I have addressed well, these hot topics that, as José was talking before and explaining, is being a hot topic through all Europe, especially recently the artificial meat, but not only, as he was saying, dairy products. It was firstly addressed in a communication from the Parliament that you have in the screen in the low left corner, if any of you is interested. So since he has already introduced the topic, I'm going only to remark that for this ultra not milk product that it's advertising in the upper corner on the left, there is a decision on the auto control jury, which is very interesting. It has been decided on appeal, and therefore we have a new resolution. And finally, the decision was that the fact that they are introducing the not milk claim to with this milk drop or only a milk drop was not misleading. Because it was not misleading on the very nature of the product, and accordingly was not contrary to the principle of truthfulness that has also been explained by José. I find this very interesting. I have to say that auto control did really did a good job here. In the auto control judgment really said that a lot of statements that were claimed by this company were not in line with the code of conduct, but not the one stating that it's not milk. So if by any chance you want more information about this or you are interested in reading it, I will be absolutely delighted of sending the resolution to you. And this is all on my side, the hot topics, and the word is to Daniel, I think.
Thank you, Carolina. And I'm going to cover the hot topics for Kenya. So the hot topics for Kenya, we've chosen to do it differently, even though I noticed there's a lot of similarity between the hot topics in the other jurisdictions that have been covered and what applies for Kenya, especially in terms of disclaimers, for food products and so on. But for our section, what we're going to do, we're just going to run through some various proposed laws that have been considered by the Kenyan Parliament and which are relevant for food advertising. And maybe just to mention at this point, we are not very clear as to when these laws will actually come into force, but they have very relevant provisions which will be required to be considered when one is engaging in advertising of food products. So the first law is the Kenya Food and Drugs Authority Bill of 2019. And one key provision in this bill is that it seeks to establish a new body, which will be called the Food and Drugs Authority, and which will be the body which will be in charge of enforcing the provisions of this act. So this act is it's largely similar to the current law, which is the Food, Drugs and Chemical Substances Act that David alluded to. And the offenses under this proposed law are also more or less similar to that act. But just to highlight that this act makes it an offense for a person to label or advertise, sell a product in contravention of the act or in a manner which is false or deceptive to a consumer. And another interesting provision in this bill is that it creates a role for county governments. You may know that in Kenya we have two levels of government. There's the national government and the county governments, and advertising has largely been a function of the national government. So this law tries to devolve the advertising function to be under the county governments. The other law is the Food and Safety Control Coordination Bill, and the key provision or objective of this bill is to ensure that there is food safety, and it does this by providing for aspects of food traceability, which will enable a consumer be able to trace the source of a particular food product, especially when there are issues of liability. So this bill provides for the requirement to provide consumers with information on prepackaged foods, and it also provides for audits to be conducted by the Public Health and Standards Board with respect to food traceability, which I've mentioned before. Next slide. So the next proposed law that we're going to look at is the Kenya Bureau of Standards Draft Labeling Standards. And a key highlight of this law is that it provides for regulations of food which are high in fat, sugar, and salt. And this is an increasing concern by, for governments around the world. And one notable thing about these standards is that they don't have provisions on the protection of advertising for minors and young children. And under Kenyan law, any person who is below 18 years will be considered to be a minor. But it's more or less of a positive step in the sense that these draft standards align Kenyan law with international best practice. So it's a step in the right direction. But then again, there are certain aspects that will need to be covered, which we'll highlight in the next slide. Next. Next is the WHO recommendation on stronger policies to protect children from harmful food marketing. And this recommendation from the WHO requires governments to adopt mandatory policies for the protection of minors, especially in respect of marketing HFFS foods and non-alcoholic beverages. So our thinking is that the draft CAB standards, which I've mentioned before, are the initiative that has been taken by the Kenyan government to comply with this WHO recommendation. The only gap that we see is that the CAB standards do not address advertising to minors. But that's as far as it goes. So we think even though the Kenyan government has complied with this WHO recommendation to some extent, there are still gaps which will be dealt with in any future legislative measures that are implemented. Next. Yeah, so that's it for Kenya. At this point, I'll hand over to Dozie to take us through Nigeria.
Thank you very much, Daniel. Okay, so we have earmarked 3 different hot topics for Nigeria. And before I go right into explain, it's important I mention that none of these hot topics relate specifically to food. They apply generally to all forms of advertising in Nigeria. Okay, so for the first one, sometime last year in August 2022, the ARCON recently banned the use of foreign models or voiceover artists for all forms of advertising in Nigeria. And this is a new policy that was announced by the Director General of ARCON during a press briefing which was held publicly. And the decision was implemented to encourage the development of local talent and also to enhance growth in the advertising sector. So by virtue of this new policy, all advertisements in Nigeria, be they for food, be they for electronics or any form of advertising whatsoever, by virtue of this ARCON's new policy, such advertisements cannot make use of foreign nationals or models, including voiceover artists. Now, there's a small challenge with this new policy, and this challenge lies with respect to foreign digital adverts that are not materially localized or necessarily targeted at Nigerians or a Nigerian audience. If these adverts are merely accessible by Nigerians through digital platforms, it cannot be expected that strict compliance will be observed. So ARCON has found out a way to regulate such adverts, and the way they do it based on practice in recent times is to take down such adverts or simply to block access to sites that carry these foreign adverts that are not materially localized, as I said. And the second topic is the implementation of a new policy by ARCON based on the new ARCON Act that requires the total content of all advertisements to have at least 75% local content. And now, this new policy is actually contained in the new ARCON Act under Section 8, subsection 1. And the adverts, this policy is effective, it took effect as from January 1st, 2023. And it was deemed necessary because, the Nigerian advertising industry is said to have, lost a total sum of 120 billion naira annually to, advertisement contents that are, that contain mostly foreign content. So what ARCON is trying to do now is to, localize the industry by promoting, the inclusion of local content as much as possible. So from the plot, the settings, the materials that are used in the advertisement, everything up as much as possible should be locally sourced. Okay, so down to the third topic. Now, ARCON in December 2022 came up with another policy requiring digital content creators to seek pre-approval prior to the exposure of any advertisement. Now, this new policy requires that digital content creators of any kind or of any form must, prior to advertising, whether food or any other kind of product, seek pre-approval from ARCON, and it applies to all forms of digital content, whether it's on TikTok or Instagram or maybe X, which formerly Twitter. And once you are either a digital content creator, a skit maker, a vlogger, a blogger, you cannot put out any adverts out there without first seeking approval from ARCON. So I think sanctions will also apply for in the event of violations. I think I'll hand over the mic to David. Hello.
David, we can't hear you. Maybe you are muted.
How about now? I was muted. Sorry about that. Thank you, Dozie. Within this topic, I'd like to talk about the protection of public health regulations, nutritional labeling 2017. It defines the manner of informing consumers that food contains a high level of salt, a high level of sugar, or a high level of fat. Next slide, please. Great. These are the labels that have to be put on foods which are being marketed to consumers. You will see them on all food stuff, all foods, beverages at food sold in supermarkets. You'll see the labels actually on the food. You'll see the label on the left is a high level of sugar. You can see it with a spoon. Salt is in the middle, and a high level of fat. The label is on the right. They seem pretty self-explanatory. You have, for salt, you have a picture of a salt shaker, which is quite clear. There has been talk about canceling these regulations because the government is claiming that it increases the prices of food, but the advocates of this labeling system claim that it has altered the eating habits of Israelis. Not by a great deal, but every little bit helps. Next slide, please. I would like to mention this class action. It was a very famous ruling. It mentions how the courts review misleading consumers. It also is very interesting from a evidence point of view. The court discussed the burden of evidence. Basically, if you claim that your food is healthy or your food increases metabolism or whatever, if need be, you will have to prove it in the case of law. Well, anyway, the defendant in this case was a manufacturer and importer of tea, Tibetan tea, and he basically claimed that the tea turns fat into energy, increases metabolism, cleanses the body, calms the nerves, reduces body weight, and the product is authorized by the Ministry of Health. Well, it was discovered that the tea did not turn fat into energy, did not increase metabolism, did not cleanse the body, did not calm the nerves, and did not reduce body weight. What's interesting is the court held that the plaintiff had to pay the defendants. The defendant had to pay the defendant had to pay the plaintiffs $14 million, which to me is quite a large sum, and I think people should consider it when they market food and advertise it. Next, back to you, Dusan.
Okay, so we went through the hot topics in all of the jurisdictions from, let's say, Europe down to Africa. We have now very quickly have to move to sanctions. How severe they are, and let's say how high is the probability that the brand owner or advertiser will get fined. But I will ask everyone just to really use few sentences because we already almost spent all our time and we still have 2 subtopics to go. So just please, few sentences about each jurisdiction. José,
Thank you.
please.
So, as you can see, there are economic and ancillary penalties. I will not go through them. I just wanted to make 2 remarks. Although we identify the risk as low, it is true that in the last few years, the number of decisions has been growing in Portugal. So the supervisory authorities are more concerned with regard to advertising issues. For example, between 2021 to 2022, the number of decisions doubled. And I also wanted to note that the decisions of the self-regulatory body, although they are not able to apply economic penalties, but they can order the entities that adhere to them to remove the advertisements. And this is a risk. Why? Because all of the main mediums, so TV broadcasters, radio, etc., are parts of this regulatory body. And so if they decide that a specific advertisement does not comply with applicable law, they will remove it. Also, just to final note, with regard to the fed foods, the National Agency for Health has set a goal to 2030 to enact legal instruments, and I will quote, to reduce exposure to the advertising of unhealthy foods and the power this marketing holds over consumers. So we can expect supervisory authorities to be more attentive to these type of issues. Thank you.
And in Spain, as José was explaining, for the self-regulatory body in Portugal, it functions more or less the same way, and autocontrol can force the advertiser to take down the advertising and revert the situation with the limits that this self-regulatory body has. And as long as the potential sanctions, fines and penalties, there are 3 different levels of sanctions that go up to 5,000 euros, 20,000 euros, and maximum 600,000 euros in courts from the Spanish regulatory law.
Thanks, Carolina. So for Kenya, the position is more or less the same with what José and Carolina have highlighted. But just to emphasize that the sanctions in Kenya can be categorized in 2 broad categories. There are those sanctions which would apply under the self-regulatory code, and this will be sanctions that are issued by the 2 bodies created under the code. This is the Standards Appeal Council as well as the Advertising Standards Code. And just to mention here that the sanctions issued by these 2 bodies will only apply to members who have subscribed to that code. So they will not apply to the general members of the public or entities who are not members of that body. Then in terms of the other sanctions which are created under the various statutes, so these are generally both fines as well as terms for imprisonment. And the fines range between approximately USD 3,300 and USD 6,700. And if a person or an entity is found to have committed an offense under any of these statutes, there is a possibility that persons in senior management, either senior managers or directors of these entities, may be held liable for these offenses. And then just to add and say that in addition to these sanctions, which I've mentioned, obviously there's also a possibility that an entity may face reputational damage, where they commit this offense, or they are charged before a court of law, or a complaint is filed before the Advertising Standards Board or the Standard Advertising Council. So it's very important that measures be taken to ensure that an entity does not face these sanctions. So I'll hand over the mic to Dozie.
Thank you, David. Okay, so with respect to Nigeria, fines lie in the form of, sanctions lie in the form of fines mostly, or prosecution of, defaulters. And it's important to also mention that previously, when, ARCON was still known as APCON, APCON did not have power to prosecute, offenders, but presently ARCON has been given powers under the new ARCON Act to prosecute defaulters. And other means of sanctions include suspension, caution, or reprimanding of the defaulter, or revocation of licenses as regards advertising practitioners. This all depends on the severity of the violation. And can we go to the next slide, please? Okay, now this is an example of one bad advertising by the company Friesland Campina, makers of peak milk, a very popular brand of evaporated milk in Nigeria. This particular advert was not well received by the majority of Christian faithfuls in Nigeria. Next slide, please. And thank you. This is another form of bad advertising. If you look to the left, the logo that says, the picture that says Happy Easter, like Agege bread he rose. This is another, form of advertising concerning, a Christian festivity that wasn't well received by a lot of Christian faithfuls in Nigeria, comparing, Jesus Christ to, a bread. So Sterling Bank eventually put up the advertisement to the right as a means of apologizing for that advertisement. And for what we saw in the previous slide and on this particular slide, these are examples of bad advertising, and ARCON has taken some form of action against Sterling Bank and the company Friesland Campina in the form of fines. Can we go to the next slide, please? Okay, now the body individuals or corporate bodies that are sanctioned have a right to appeal against those sanctions. Now, we have two bodies that can sanction either individuals or corporate bodies. And the first of these bodies is the Advertising Offences Tribunal. Now, the Advertising Offences Tribunal is that body under ARCON that is charged with prosecution of individuals in the event of violation of provisions of its act. And appeals from this body lie to the Court of Appeal, directly to the Court of Appeal. And the second body is the Advertising Practitioners Disciplinary Committee. Now, this committee, let me say, regulates the practice of advertising and is also responsible for sanctioning advertising practitioners in particular, not ordinary individuals like digital content creators. So appeals from decisions of the disciplinary committee lie directly to the Federal High Court. And so we also had a case in one of the previous slides, and we highlighted very briefly a case that's between ARCON and Meta, previously known as Facebook. ARCON actually instituted a case at the Federal High Court against Meta, claiming, I think, 30 billion naira for putting out an illegal or an unapproved advertisement. So these are some of the cases that are presently, ongoing with ARCON. And the fines as regards individuals is usually between 500,000 naira, which is the equivalent of about slightly over 600 US dollars. And for corporate bodies, the fine is usually 1 million naira, which is, I think, above 1,100 US dollars. For individuals, there's usually an option of either a jail term of 2 years or payment of fine. And in some cases, ARCON actually, issues both the fine and the jail term as well. While for corporate bodies, it is either a fine and then the assets of that company, that was all the assets that were used in putting out that advertisement, will be forfeited and taken over by ARCON. So I think that is it. Thank you. Hand over to David.
Thank you. In Israel, there are the usual civil proceedings that you can hold against advertisers. If you prove that you were misled and you can prove actual damages, the court will award you money. Also, the courts will issue injunctions. Injunctions are very happen a lot in advertising and marketing cases because the court can order the advertiser to amend or to remove his advertisement. Under the Consumer Protection Act, a court can hit you with a fine of up to $17,000. There are, in theory, criminal sanctions, but they're very extreme. But you should, when you're talking about food and beverage, you should be careful. If you're going to tell the public that your product is safe and healthy, and it's not, I can see, in theory, criminal actions against you. Under the class action law, as you saw in the former questions about hot topics, in a case in a class action law, the plaintiff was awarded $14 million. So it can be quite high. That's it. Back to you, Dusan. Back to you, Dusan.
Yeah, I'm here, David. I was just unmuting myself as I was reading
Okay.
the question. We have a question. Charles Dalglish is interested about the positions of jurisdictions of Portugal, Israel, and Nigeria, and Kenya in Africa about HFSS, high fat, sugar, and salt. Let's say, what is the regulation? What are the recent cases, and probably what are the sanctions recently used?
Are you talking? Should I answer?
Probably let's say go backwards. So please, David, start, and I will just go up.
Okay. You can, under the Consumer Protection Law, you can get a fine of $17,000. You can be requested to remove the product from the shelf. I am not aware of a case precisely on that topic, but if I find one, I'll send it over to you and send it over to the person who asked the question. Back to you, Dusan.
Okay, I will just go back to Dozie. Like, say there's a specification of the question. Like, if a country or jurisdiction represents a typical position, which means that, let's say, HFSS products has to be specially labeled, and let's say their advertising is, let's say, a bit limited, or let's say put away from the main times, etc., etc. Dozie?
Okay, thank you, Dusan. Okay, with regards to Nigeria, the NAFDAC will be the body responsible for, advertisement of all food products, including, fats and sugars and the contents of, food products regarding this particular, let's say, elements of food. Now, the food products advertising regulations is also the specific regulation that will be used to, check whether or not the particular advertisement relates to the specific, description as put forward by the advertiser. And if the requisite approvals to advertise that food product as it should be, and including meeting up with the labeling standards, the specific ingredient contents, making full disclosure of every single content of that particular food product. If it is found that, first of all, this advert was not approved, or that food product was not registered, or if it is found that the labeling is untrue, then such an individual is going to be fined by not just NAFDAC, but the Advertising Regulatory Council of Nigeria, because generally speaking, the rules of advertising in Nigeria provide or require that you must be, your advert must be legal, it must be decent, it must be honest and, truthful. So every single advertiser is required to, comply with these basic requirements regardless of the particular substance that you intend to, put out there as an advertisement to the public.
Okay, so thank you, Dozie. Then David, Carolina, and José, in this order, please quickly comment on HFSS in your jurisdictions.
Thanks, Dusan. So for Kenya, the bodies that will be involved with this will be the Competition Authority of Kenya from a general advertising perspective, as well as the Kenya Bureau of Standards with respect from a labeling perspective. So generally what I would say for Kenya is that the standard is a bit lower when compared to the other jurisdictions that we've discussed, from the sense that we don't have specific regulations that cover advertising or labeling of HFFS foods. And also the proposed laws that we highlighted do not specifically provide for the protection of minors, marketing of these kind of foods to minors. So that appears to be a gap in the law. And even if these laws are enacted, there'll still be a gap there. But generally just to add that the Kenya Bureau of Standards in enforcing the labeling requirements can take a number of actions. They can levy, penalties. They can also impound products which are found to be non-compliant. And they can also, lodge a complaint, which may lead to a criminal prosecution before a court of law. Yeah.
Thank you, Daniel. Well, I would dare to say that Spanish position in this regard of high fat and salt and sugar products advertising represent the typical position in the UA. It is easy because, as already mentioned, we have a common regulation that translates into national regulation that normally tend to harmonize. So in this respect, I would say that, Spanish position in this regard is typical position, and it gets stricter and stricter, but as far as I know, every other country in Europe.
Yeah, for the sake of time, I will take advantage of what Carolina said. As a EU member state, Portugal is the same. So not much to add. I just wanted to add that as far as I'm aware, there is still no enforcement on these rules in Portugal, but the decisions of the administrative authority are not public. So it is possible that one or two decisions have been issued or not.
Okay, thank you, Carolina and José. And we can just start our final section, which is our key takeaways. So I'll ask every one of you just to stress on what's important, and we can start just by you, José. Go ahead, please.
Thank you. So our advice to advertisers will be to define a step plan. You have a specific product, find out the type of product and the special rules that apply to such products. As we saw during the presentations, special rules apply to specific products. So not only the general rules must be complied with. And once you have identified that product, consider all the rules and apply, be very sensitive to the claims that are used, because nowadays supervisory authorities tend to be more protective of consumers, and claims that may be deceptive will be obviously unlawful, and surely the supervisory authorities will enforce against those. And also there is always the risk of consumers to submit specific claims and claim indemnities where applicable, of course.
In my case, I want to just give you three highlights. The advertising in general, not only in food and beverages, but in general, really needs to be clear, truthful, objective, and not misleading. This is way clear in all kinds of regulations in Spain, Europe, and self-regulatory codes. But specifically for food and beverages, there is extra protection to the consumers in general, and extra protection to minors. And the thing that you need to bear in mind is that this extra super protection for minors is getting stricter, and the regulations tend to put an effort to protect the minors in this particular area, and there are regulations coming hopefully in the near future that will strengthen the protection to minors.
David, do you want to take us to Kenya? Yeah.
Yes, thank you, Carolina. Our advice to marketers and advertisers are: first, ensure advertisements containing health claims in relation to fats, vitamins, and minerals can be readily substantiated. Second, do not make any representations or omissions or engage in any practices likely to cause unreasonable risk or harm to consumers. Third, provide recommended data reuses and food and beverage warnings for uses that may harm consumer health. Next, ensure advertised and marketed products adhere to the Kenyan standards prescribed by Kenya Bureau of Standards. And lastly, but not least, implement or review internal marketing standards and policies.
Thank you, Danny. For Nigeria, it is actually important to understand the fact that advertising in Nigeria is strictly and jointly regulated, by different government bodies. Although I had mentioned earlier that the ARCON was primarily responsible for the regulation of advertising in Nigeria, there are also other industry-specific bodies that are responsible for the regulation of advertisement or advertising in those sectors. So it's important to always keep this in mind. And then it's also important to understand the fact that the ARCON's powers have been enlarged to include prosecution. So advertisers in Nigeria need to understand the fact that ARCON now has the power to prosecute defaulters, and the sanctions can be quite steep, even though the benchmark for private individuals is about 500,000 naira, and for corporate bodies is about 1 million naira, but it can be higher, including the prison sentences that can be passed. It can be a lot grave. Then it is always good to imbibe good advertising practice, because the end receiver is why consumer receives correct information, and they are not misled by the content of advertising. So it is always good to imbibe good advertising practice. Then advertisements, no matter the channel of dissemination or exposure, must always be pre-approved. So any person or corporate organization or corporate body coming into Nigeria to put out an advertisement must take note of this fact, that whether it is radio, TV, social media, whatever form, print media, whatever form you are putting out that advert, you must first obtain pre-approval from the ARCON's advertising standards panel before you can put out such advertisements. Thank you.
Thank you, Dozie. No matter what topic I talk about in these webinars, I always tell people, do not mislead consumers. And it's especially true when we're talking about food and beverage, because these have health implications. Again, be extra careful when targeting minors. I always mention this in webinars. Same with food and beverage. Now, as to food and beverage, you have to be aware of the special regulations relating to the labeling of high content of salt, sugar, and fat. That's it. Back to you, Dusan. Thank you very much.
Thank you, and that's basically all from us today. We already answered one question. I have to ask if there are some other we can still answer while people will be still thinking whether to pose or not to pose the question. Let me thank you, the panelists, José Pereira, Carolina Montero, Daniel Mwathe, David Opijah, Dozie, Ezeh, and David Wolberg. Thank you to all of the attendees that you have stayed with us for so long. We hope that we did not ruin your agenda for today. As one of the closing remarks for that, let me invite you for our next webinar, which is going to take place on December 7th, and it will be like one of our most popular webinars, which is Global Advertising Law Year in Review. You will see speakers from various jurisdictions. It's on December 7th at 12 p.m. Eastern Time. Finally, before saying goodbye to you, let me take your attention to the resources. You can find a lot of information, a lot of contacts on our webpage, galalaw.com. And of course, do not miss, and if you are interested in advertising and marketing law, please subscribe, or feel free to subscribe to our blog, which you can find at blog.galalaw.com. You can see lots of articles from various jurisdictions, like 5-minute reads, everything you need to know or to be in pace with the advertising and marketing law developments all around the world. So finally, this is the end of the webinar. Thank you again for your attention and for your participation. Goodbye and see you soon on any GALA event. Bye-bye.
Thank you, Dusan.